Hello. Hello. Can you see us?
Yes.
Can you see the people besides the presentation?
They are not joining us yet.
You're not seeing any people.
I'm asking, can you see me?
Is that Onyekachi?
Yes, can you see me?
I can see you, but you're far away from the camera.
Okay, can you see two other people with me?
Yes.
There's someone, okay, that's cool.
Yes. Okay, I can see you now, and I can also see the students sitting.
All right, so most of the students have left campus. It's a weekend, so they've gone home because I made a mistake as to the timing, and you know it is. It's late in the evening here. I'm not in the country. Yeah, sure.
Is your presentation supposed to be displaying on the screen?
No. They are the one making the presentation.
Presentation. All right.
Yes, thank you. Yeah, Hussein?
Yes.
I want to take my position. Confirm you can see me.
Yes, we can see you.
Yeah. Okay. And you can still see the lady here?
Yes, I can see her too.
All right, thank you.
Holy God.
So saying confirm that the participants are also getting ready.
Yes, ma'am. You're coming, you're joining the meeting. I think we are starting now. Starting now.
Hello, everybody. Good evening. Hello, Ms. Onyekachi. Hello.
Hello. Is that
Hello, Philip. Hello, Christian. How are we all doing today?
Hello. How are you?
Thank you very much.
How has the program been so far? How has it been enjoyable? Has it been enlightening? Has it been insightful, or just nothing extraordinary? Could you share your experience, Christian, please?
Actually, it was good experience and exposure for me. I was imparting knowledge. Okay, now you can see me, sorry. So for me, it was very nice to get to interaction with the different people and with the different jurisprudence.
Okay.
And it's throughout the weeks, it's getting more interesting. So I believe the further we go, the more interesting it gets, and the more I get more knowledge from the mentees as well, the mentors. So I like it so far. It's very interesting.
All right, that's amazing. That's nice to hear. So could I have Eberechukwu, please? How has your experience been throughout the program so far? I mean, this is week 4. You've probably attended like 4 programs of the internship sessions. So how have you enjoyed the program, or have you not enjoyed it?
Well, it was quite good, but I had some difficulties because we're not in the same time zone.
I'm doing okay.
We all have to work at the day, or we all have to go to school. So I'm 2 hours ahead, so I have to stay late.
Oh.
Yeah, I had to stay late for our group discussion. That has been a challenge, but it's good for me, and getting to learn new things, and making friends already, making good connection. After all, for me, what I've learned so far is creating connections,
Okay.
being
Yeah.
able to make persons throughout the continent is a nice thing for me, because I have an experience benefiting of such thing.
Yeah, I understand. So I would like to
Yes.
have another mentee share their own experience. We would have Chidiogo. Is Chidiogo on the call? Is she present? Hello, Chidiogo.
Hi.
Okay.
Good evening.
Okay. Hello. Please, I would like to
Hi.
know your experience so far. How have you been enjoying the program, or has it been tiring? Has it been draining, or has it been an opportunity for you to learn?
Well, it's an opportunity for one, and again, I just recently joined. I joined on Monday or Tuesday, so I'm still very
Okay.
new. So this is like my very first Zoom meeting. But so far, it's been research, research all the way, and it's been good.
So we'll be going into icebreakers just to like warm ourselves up a little bit. I would like it to be as interactive as possible, so that the more interactive, the more fun it gets. So I would like to know, like, has anybody tried out any odd food combo? Maybe you've had something beyond the normal bread and tea, or you've had something as odd as pancakes and rice, or something like that, something crazy. Any crazy combo you've had, growing up, or anything you've seen on the internet that's just really nasty? Mr. Hussein, could you please go?
When I was in boarding school, okay, I take noodles and bread. I don't know. Have anybody eaten that?
That's really not bad. That's really not bad.
That's
I
amazing.
think most people did that growing up.
Yeah, noodles and bread. So I think that's one of mine. I don't know.
Okay.
Somebody like
Okay.
Philip. Let's ask Philip. Philip, are you on the call with us?
Yeah, I'm on the call with you guys. Yeah.
All
Yeah.
right.
So I think it should be rice and bread. It's actually crazy. It's actually crazy. Rice and bread, seriously. It's nice.
Okay, could you
It's not
have
absurd, but it's nice.
rice
Try
and
it. I
bread?
advise you to try it. It's nice, bro. Seriously, enjoy it. Like, it's
Wow,
excellent.
nice. Okay.
When did you eat
I'm
that?
going to try that.
I tried it as recent as, I think that's last month, and since then I've been a faithful consumer of that product. Seriously.
All right. Could you please have Babatunde Lawal, please? I think that would be the last person you will have. Is Babatunde Lawal on the call? All right.
Yeah.
All right.
I think he
Yes,
just
I'm here.
unmuted.
Okay.
Yes, I'm on the call.
Could you please know like the oddest food combo you've had growing up, or maybe much recently, like Mr. Philip said?
I'm very picky what I eat, so I don't have.
Okay, you don't really try the crazy things.
Yeah, I don't try the crazy things.
All right. So we'll be diving right into the session. So hello everybody. My name is H.M.A. Roberts Nanakalum. I'll be the anchor or the compare for this session. So would be just having a brief overview of what the JIPPC program is all about. Now, the program is particularly an intellectual property program that holds quarterly, and it cuts across the African continent. So mentees are expected to gain valuable advice, training, networking opportunities, mentorship, and internship. It also provides us with like discussion forums for us to better understand various areas of law, ranging from energy, patent drafting, fintech, and intellectual property, depending on the module you decide to go with. We have a YouTube handle, we have a Facebook handle, so feel free to check us out on there. The objectives of the program include providing easy access to quality professional guidance and training for students and young professionals across the African continent. So it's not really Nigerian based, it's more than, like just a while ago, we had Christian talk and she's like 2 hours ahead of the Nigerian time zone. And we also seek, JIPPC also seeks to encourage dialogue and networking across professionals. It also seeks to transform mentees into well-meaning professionals through the whole discussion forums and everything we have. We also seek to facilitate mentorship, internships, scholarships, and job placements for our mentees, just like the one we're having right now. Okay, so going right into the announcement, I just want to flag it up that, registration is ongoing for the first quarter ahead of 2023 for the JIPPC session. So if you know a friend, or if you like to recommend the program to a friend of yours, or someone who you think would find this program interesting or enlightening, then please do. I would also like to encourage each and every one of us to put on our videos, because the session will be streamed live, and it would be aesthetic having everybody's face showing. So we'll be going right into the heart of the program right now. We'll be looking at the mentors that we have for today. First of all, we have Mrs. Ngozi Onikachi on the call. So Miss Ngozi Onikachi is a graduate with honors from the Olabisi Onabanjo University, and she was called to bar at 14 years ago. She served with the Lagos Aid Council Osun State Charter, where she initiated and anchored a TV program on law awareness, You and the Law, which she used as an opportunity to educate the citizens on their rights and the access to legal aid services in Nigeria. She also worked in the private sector as a legal company legal assistant in a media outfit. She also joined the Civil Service of Nigeria in 2014, and currently she's a senior assistant at the registrar in the Commercial Law Department of the Federal Ministry of Industry, Trade and Investment, where she's serving in various capacities. She's a beneficiary of the World Intellectual Property Organization sponsored master's program, and just recently she concluded her Harvard Copyright X program on scholarship. She's passionate about intellectual property and its growth in Nigeria, and believes in an IP-enabled and engineered civil service Nigeria. She's currently one of the innovation think tanks and future leaders of the Federal Civil Service through the Innovation Challenge and the Leadership Enhancement and Development Program. She's a peace advocate and holds qualifications in peace and conflict studies from the Institute of Peace and Conflict Resolution, and a master's degree holder in National Open University of Nigeria. As a peace advocate and as a passionate intellectual property professional, she stupendously combines both skills in creating awareness for startups and talented Nigerians on social media, in the legal space, and in the government. The results have seen businesses averting infringement acts, collaborate and settle their disputes amicably and administratively. It has also earned her titles such as a Lead P Future Leader, a Federal Civil Service Innovator, and an African Peace awardee for 2021 and a nominee for the 2021 ESQ under 40 Nigerian Legal Awards. Also, we'll be having Miss Lenkela Usiebue. Oh, sorry if I got the name wrong, but I think it's Linkela Usebiu. I hope I pronounced that correctly. So Miss Linkela is a senior lecturer at the University of Namibia's School of Law. She has 9 years of experience under her belt in the legal academia. She teaches the law of intellectual property and law of delicts. She is a holder of master's degree law obtained from the University of Stellenbosch in South Africa and is currently pursuing a PhD within the area of intellectual property at the University of Cape Town. Her research interests lie in intellectual property law specifically, as well as commercial law and development. So like I mentioned earlier, this is week 4 of the program. So I hope by now that, I hope by now that everybody is well settled into the program, except, the person that informed me earlier that, she just joined recently. I hope that the easing in has been an amazing one so far. So we'll be going into the presentations now. Like we should be aware of, we have 4 groups, and each group is assigned 8 minutes to speak on the topic that they were assigned to research on. So I'll be calling on the presenter for group 1 to please begin presentation. Please remember to share your screen. Remember to turn on your video so that we can see your beautiful face or your handsome face, depending.
Presenter for group 1 is Adedamola Adetula. Are you in the call with us?
Yes,
Please.
I am. Good afternoon, everyone.
Good afternoon.
Yes, a colleague of mine will be sharing the screen very soon. I'll just wait for a few seconds. I don't know if it's online. Okay, while he's at it, I'll just start because of time. Good afternoon, everyone. My name is Adedamola Adetula, and I'll be representing group 1. I would like to appreciate JIIPC for this opportunity and to learn. Yeah, so for group 1, we'll be talking about the registration of IP. Okay, thank you very much. We'll be talking about the registration of IP at national, regional, and international level. And firstly, we'd like to look at what, the first slide, we'd like to look at what a registered intellectual property means. And it means that all rights that are registered, filed, issued under the authority of any governmental body, including patents, copyrights, trademarks, amongst others. So it means that when a right is being registered under governmental bodies, and examples of these governmental bodies include Nigerian Copyright Commission, amongst others. So instead of it's possible for a person to have a right, but however, in an instance where it is not registered, it can't be protected. And that's what registration helps with. So when a right is being registered, when these rights, the patents, they are being registered, applications are made, the trademark is registered, what happens is that in an instance where such rights is being encroached by a third party, it causes for an infringement, and such a person can actually get damages for it. And because you know that, okay, this is what I registered for, I was the first person to do this, the first in time, and at the end of the day, I have an higher hand over another person coming up and claiming what I invented. So I'll be moving on to my next point. One thing is protecting one's right interests at the national, regional, and international level is very important. However, you need to be aware that on how it should be done. So basically, we have like I said, the national, the regional, and international. So for the national level, I'll be using Nigeria as a case study on how these rights can be protected in Nigeria. I mean, our intellectual property rights. So for the copyrights, when we talk about copyrights, it's protection of these rights is actually automatic because we know that copyright is an intangible asset. So once something that is intangible, meaning that something that cannot be touched, and It's and which means that you don't have to register it. But according to the Nigerian Copyright Commission that was founded in 1989, they established that they later came up with something that, okay, in as much as the copyright can be automatic, you getting registration for it is automatic, you can actually, there's a voluntary notification process that can be done where you notify them stating the time and the existence of and the date that such work was created, which will actually help so that, okay, in compiling information of, okay, this thing is actually your work and it is not for another person. And the next one is for the trademark. So trademark has another process. And in registering for trademark, the first thing you need to do is to file an application to the registrar of trademarks. There is a registrar of trademarks, and it is different from CAC. The next one is name and address of the proprietor. And in that slide, we also stated that the representation of the trademark to be registered. And lastly, indication of the classes, which means that there are several classes. So if whatever it is that you're registering, you need to find the class, or whatever it is you're registering for your clients, you need to find the class that it falls into, which is very important, meaning that as lawyers, we need to, and even as law students, we need to have this understanding and this knowledge and know how to advise our clients appropriately. The next point is patents. For patents, how it can be registered. So it must be in line with Section 1 of the Nigerian Patent and Design Act. We state that before a patent, an innovation, an invention can be registered, it must be new or novel, meaning that it must be new. It must result from inventive activity, and also it must be capable of industrial application. And one thing is, this application is actually made, unlike the trademark that is done to the registrar of trademark, this is done to the registrar of patents. So we need to understand that. And the process takes about 12 months. It's actually quite long, and it's worth it because it requires a lot of due diligence. Like you can't compare it to the normal. If you're doing like a business registration, that might just take like in 1 day or probably 2 days, it's done. But this one, a lot needs to be imputed to it. So the next one is for industrial design. For industrial design, it is registrable if it is new and if it is not contrary to public order or morality. Okay, I'll just move to the regional level. So the regional level, okay, let me state for industrial design that it subsists for 5 years, and however, it's actually renewable. So let me go to the regional level. So to the regional level, I want to state that there are actually several regional organizations that covers for this. So meaning that you can actually register your trademark, you can register your copyright at the regional level. And examples of these organizations are the European Union, and we have about 27 countries in this. We have the Benelux, we have 3 countries, we have the African International Property Organization, we have 17 countries, we have the African Regional Intellectual Property Organization, and we have 11 countries in this. And what this means, however, we have a challenge, and the challenge is that sometimes there could be conflicts in this trademark, and these conflicts can actually be, most times they're actually noticed during the process of examination, and they could mark it as a form of opposition with this, which could be a difficulty. So for instance, a person is coming, okay, I want to trademark this. There could be from another, amongst the members of that particular region, and which could serve as a form of conflict. And that is why we have these organizations that they help in deciding. So a country that wants to be a member of this, they need to apply. And once they become members of these organizations, they are bound by whatever laws that govern these intellectual property rights in that level. So at the international level now, at this level, it allows trademark owners to register their trademark at multiple jurisdictions. So basically, international level, meaning that the whole world, like at the international level. And this is governed by the World Intellectual Property Organization. So, for instance, where a trademark is meant to be registered, it could be registered just by a simple application. So you don't have to do it, okay, because I want to get to the international level, let me first start from the local level, then I'll now move to regional. No, just a single application actually suffices. And that can be done using the centralized filing system that is administered by the World Intellectual Property Organization. International Bureau. Also, beyond doing that, WIPO will also make sure that due diligence is being done to ensure that there is actually no conflict between the interest of parties. And furthermore, once that is done, it can take a process of about 12 to 18 months. So before that registration will go through, it actually takes a while. And in an instance where a country realizes, so when a person registers, that application is sent, then WIPO then delegates this particular registration to a particular country. So once this is done, the country is expected to deliver probably that country, that particular registration skill tree within 12 or 8 months. And there are instances where WIPO can even like decide to designate it to another country, just based on their discretion. Furthermore, such registration, once it has been approved, can also be renewed by the Madrid system, which is under WIPO. Please, I hope you're following.
Yeah,
Yeah.
sorry,
I'll be
Ade.
running over.
Ade, I'm sorry. Could you round up in a minute, please? Your time is
All
up.
right. Thank you. All right, thank you very much. Sorry about that. Yeah, then we have the trade secret. So trade secret, that's the World Trade Organization agreements. That is what governs that. And for patents at the international level, the internationally it is actually possible to seek protection of an invention in a large number of countries, and which means that for patent at international level, it actually governs like a large number of countries being involved in it. And lastly, for the industrial designs, the Hague Agreement is what governs the industrial designs, and the first one was adopted in 1925. And however, and in conclusion, this allows industrial designs to be protected in multiple countries and regions with minimal formalities. So I hope that as I conclude this, I just really hope that we've been able to understand how the various processes of registration entails, both at the international, the local, and the regional level. Thank you very much.
Thank you so much, Ade. Thank you. So I'll be calling on the members of Group 2 to please commence their presentation so that we are not falling behind schedule. Group 2 members, please. Your representative.
The presenter for Group 2 is Gabriel Edibo. Gabriel Edibo, are you in the call with us? Okay, if Gabriel is not with us, I think the backup presenter for Group 2 can start presenting. Or Group 3 presenter, if you are ready, you can step in. Presenter for Group 3 is Lawal Abatunde. You can start presenting if Group 3 is not ready.
Okay.
Thank you.
My name is Babatunde Lawal. I am the presenter for Group 3. First of all, I would like to appreciate the JIPPC community for this opportunity provided to students and professionals intending to further their intellectual property knowledge. So I'm going to the business of the day. Okay, I'm trying to share my screen, so. Well, I don't know. Can you see my screen?
Not yet.
No, not yet.
Okay. Well, I think I should just go on with the presentation. So yes, Group 3 is talking about the enforcement of intellectual property. First off, to understand the meaning of intellectual property, we sort of explained slightly what intellectual property rights means. Intellectual property rights are exclusive rights granted by law to persons over the use of innovation creations of their minds as opposed to personal or real personal properties. These rights allow holders of patent, trademarks, or copyright works to benefit from their work and take necessary action against any form of infringement. However, before an infringement can be said to have happened, there must be an intellectual property right in existence. Also, before an enforcement can be said to be done, then there must have been an infringement on that said intellectual property. So now we went further to define what infringement means. IP infringement refers to the violation of a protected intellectual property right. The act of taking necessary action against any act of infringement is known as enforcement. So now we explained what IP enforcement is briefly. IP enforcement is defined as a legal action or mechanism one may take to protect his intellectual property right and ensure that no third party uses them without proper authorization, as well as obtaining compensation for losses when these rights are encroached upon. So this enforcement of IP involves various administrative and judicial mechanisms. There are two, we consider two options for the enforcement. First, the physical enforcement option, and then the online enforcement option. And okay, to briefly explain the physical enforcement option, there are two basic steps to take before there are two basic steps to enforcing an IP right physically. The first thing a person has to do is write a cease and desist letter to the infringer. This is like a pre-action notice, sort of. The basis of the letter is to inform the alleged infringing party that they are doing something that infringes your IP right. This may be to scare the alleged infringer to desist from continued usage of the IP right. However, when the person still fails to desist, then we can proceed to the next step, which is litigation. Sometimes some infringer thinks their act is not an infringement on your intellectual property right. So in that case, both parties have to resort to litigation to decide who owns the IP right and who has infringed on the IP right. And like every other aspect of law, not all cases go to the court. So alternatively, IP issues can be resolved at alternative dispute resolution centers or general settlement between the two parties rather than take the option of going to court. We took our time to list out some cases that have been decided, some intellectual property rights cases that have been decided. We have here the Item Pilar KG versus Manufacturing Process Limited, known as Anton Pilar order, where a plaintiff brought an ex parte application supported by an affidavit showing reasonable cause to suspect the presence of items used or intended to be used for making infringing copies of his work in the premises. The court granted the order, and the plaintiff conducted a form of civil search, different from a criminal search, usually conducted by the police in the premises of the suspected persons. This is to seize, detain infringing copies and stop further circulation of such. Also, we briefly considered the case of Hoffman, LaRoche, and Co. AG versus Secretary of State for Trade and Industry. In that case, there was also an interlocutory injunction sought to freeze a situation before further damage could be done. Then now let's move to the online enforcement option. Just like we all know, like the internet has efficiently created a wide range of opportunities for businesses and individuals to communicate their brand messages and reach a target audience or to otherwise inaccessible markets. However, this has created room for IP infringement, which could involve stealing of brand identity elements and using them to disseminate fake brand or counterfeit products and services. Yes, like every other thing, like every other thing else with the internet, monitoring and enforcing IPR online can be challenging. That's why efforts has been made to assess and understand the wide range of mechanisms needed to resolve IP disputes when they occur on the internet. Um, as the voluntary arbitration, this provides an efficient mechanism to resolve multi-jurisdictional online disputes and retain business relations as agreed upon by the parties. It enables right holders to pursue multiple proceedings, reduce cost, and save time required to resolve such disputes. And then there's the criminal measure. IP right holders can combat infringement, such as counterfeiting, with the help of law enforcement agencies to prosecute and stop such illegal operations. For instance, in the UK, law enforcement agency, the police, intellectual.
Hello, Mr.
Yes.
Babatunde, please could you round up, please? 8 minutes have elapsed. Well, we'll be giving you like 1 minute to conclude, so you're not just like in the middle of a sentence.
Okay. So there's the crime measure, the administrative and custom proceedings. So basically, for the crime measure in the UK, there's a body, like a police unit put in place to combat that. Also, there's the administrative and custom proceedings. We can see in China also, like there's a department, there's an administrative department for industry and commerce in China that is set up to tackle IP infringements in this area. In conclusion, in the same way a property owner must take steps to stop someone from infringing on their physical property, an IPR holder must also take steps to stop someone from infringing on their intellectual property rights. So basically, that's all we have. Thank you.
Thank you, Mr. Babatunde, for that presentation. I, was able to learn quite a handful about IP enforcement. We'll be going on to Group 3. Group 3 representative, please, could you comment your presentation?
I think he's Group 3, right? So we are going back to Group 2.
Okay,
Yes.
the person we just took now is Group 3.
Group 3, yes.
Okay, so Group 2, are you ready now? Representative for Group 2, are you ready?
Okay, we can skip Group 2 and go to Group 4. Then we'll come back.
Or can we go over to Group 4 whilst waiting?
Yes. Group
All
4,
right,
please.
Group 4, please. Group 4, please, your representative, please. Could you comment presentation?
All right, thank you very much. Thank you, everybody. So my name is Philip Wonsu, and I'll be taking the presentation on behalf of my team, or my group rather. That's Group 4. So please, Christian, do it to share the slides. All right, so moving fastly, our topic for today is focused on the arbitrability of intellectual property. That's to say whether or not an IP property can be an IP dispute can be resolved through the means of arbitration. So arbitration as a form of dispute resolution and popularity, and this is because it is associated with so many benefits when it comes to resolving of disputes. So the benefit includes confidentiality, speedy resolution of disputes. Please, Christian, can you share the slide? Can you all hear me?
I am sharing the slide.
All right, thank you very much.
Can you see it?
No, I can't see it.
Okay, wait.
Okay, so let me move on while she's about to share the slide. So as I said, arbitration is fastly increasing in popularity because of its the benefits associated with resolving dispute by virtue of alternative dispute resolution means. When we talk about the arbitrability of IP disputes, what we basically mean is whether or not a dispute ensuing from the domain of intellectual property can be resolved by virtue of arbitration, mediation, conciliation, etc., or can be resolved by virtue of litigation, traditional litigation. So national community and Nigeria can be resolved by, okay, the slides are here. Okay, so IP disputes, as I was saying, can be internationally, it is settled. The IP disputes can be resolved by virtue of ADRO means, and in Nigeria as well, IP disputes can be settled by virtue of ADRO means. So to evince the applicability of resolving IP disputes by virtue of ADRO means internationally, the WIPO, the World Intellectual Property Organization, actually has a Center for Arbitration and Mediation. And this is an independent body that works with WIPO for the sole purpose of resolving issues that come from intellectual property through relevant ADRO means. Okay, so moving fastly. Okay, I think you should go to page the second one. Yeah, go up. Okay, yeah, there. Yeah. So when it comes, there's some inherent characteristics of intellectual property that makes it suitable for being resolved by virtue of ADRO means. So these characteristics include technicality, international dispute, urgency, finality, and confidentiality and aforementioned characteristics. So I've seen instances wherein when an IP dispute is brought to the courts, sadly, the judge who is sitting for the matter, who is in the trial for the matter, might not really be acclimatized to the rudiments of intellectual property. And apparently, by virtue of his little ignorance on IP, it might not really bet sufficient justice. So secondly, it can international dispute, urgency. Through arbitration, IP is swiftly and fastly concluded compared to litigation that is, as we all know, popularly associated with delays and other forms of hindrances. Then finality of requirements. So a court case can be appealed, but I'm not really sure, I stand to be corrected, I'm not really sure if an arbitral award can be appealed. So moving to the next slide. To the next slide, please. All right, thank you. So we have provisions in Nigeria that makes it feasible for IP rights to be resolved. Yes. So I'll mention these provisions categorically. So please go up, not this slide, go up. I'm done with this one. Yeah, this one exactly, thank you. So dispute arising from IP can be resolved by arbitration by virtue of section 13 sub 3 of the Trademarks Act. So this section provides that in a situation where there's an agreement or there's an agreement that parties to the IP agreement or IP contract should affix a arbitrational clause. So in such a situation where there's a dispute and altercation between the agreeing parties, the matter can be resolved by virtue of arbitration as a reason of the arbitrational clause. Yeah. So the next one, the court can order that the dispute be settled amicably. Exactly. So I believe in some, I stand to be corrected, but I believe in some jurisdictions, even in Nigeria, we have seen situations wherein is a condition precedent before you bring a matter to court. The court expects you to exhaust other alternative means, indoor means of resolving that state dispute. So in a situation wherein those means are not sufficiently adhered to, definitely the party does not really have the local standing to bring the matter to court. Exactly. So the third one, provisions are made by other laws. So we have the UDRP, which stands for Uniform Domain Name Dispute Resolution Policy. So the ICANN, that is the Internet Corporation of Assigned Names and Numbers. The ICANN actually were the one that produced the UDHRP for the purpose of swiftly resolving issues that are associated with domain name issues on the internet space, etc. Okay, so please just go up. Can you go up, please, Kristen? I'm done with this slide. Okay, I think it's advantages of IP, advantages first before disadvantages. Okay, exactly, thank you. So we have numerous advantages for the purpose of our discussion today. We limit ourselves to these 5 mentioned advantages. So confidentiality. So normally arbitration itself in its nature is a confidential method of resolving disputes, because first of all, an award that is manufactured by virtue of an arbitrational tribunal cannot really be exposed to the general public for consumption. It's beneficial to IP because it's in choosing the arbitrator. So the parties to the arbitrational agreement has the latitude to decide who should be the person that will place them. Actually advantageous because it gives them the feasibility of picking somebody who is properly acclimatized to IP space in arbitration. So fast completion, apparently ADR arbitration is swift and faster than litigation, is more convenient, and the finality of the award. So let's go to the next slide, please.
Sorry to interrupt you, Mr. Philip. Your time is running short, so please conclude as fast as possible.
Thank you very much. I'll be very, very fast. So disadvantages associated with what's it called? With arbitrating IP, we have lack of uniformity, we have the requirement of arbitrational clause while making the contract, we have lack of interim relief in most cases, and we also have the requirement of
I don't know, I can't hear Mr. Phillips. Can you all hear him?
I think he's probably having network issues. I think he's having network issues.
Having risk specialized items. The next slide.
Is Mr. Phillips speaking? I can't hear him. Can you hear him, HMA?
No, I can't hear him.
I'm back.
Okay, so please, could you conclude, please? Time is not on our side.
Okay, so moving to the conclusion, we mentioned case studies, but due to time, we'll omit that. So conclusion, in developing nations, we have seen that arbitration, ADR, is a proper method. It is a proper dispute resolution method that is being employed in several civilized nations. And Nigeria, we advise Nigeria to also take part. Nigeria is already doing this, but also advise, we also inspire an aggressive campaign that this method of resolving IP becomes a standard in Nigeria. So thank you very much. Thank you for the time. So this is the end of our presentation. God bless you all. So I'm done.
I think you are muted. Echeme, you are muted and you are speaking. We can't hear you.
Oh, so sorry. So thank you, Philip Wosu, for your presentation. I don't know if if group 2 is ready, or if we should just proceed, because are the group 2 members ready now?
Okay, I'll be calling the names of all the group 2 members. Any of them in the call can step in, please. Group 2 members, anybody can present on behalf of the presenter and the backup presenter. Stephen Ifeanyi, if he's in the call, you can present. Okunyi Daniel, Miriam Osiri, Mahmoud Aisha, Jennifer Omohe, Ijeoma Nukeoma, Edibo Gabriel, Chisemdi, Chidiogo, Aluko Arowolo, Sobola, Abimbola, and Hikmat Oluwalola. So please, any of you on the call should present on behalf of group 2. Okay, to save our time, please, you can continue, Eche.
Okay, so to save our time, like Mr. Hussein mentioned, we'll be skipping group 2 for today. So we'll be calling on Ms. Oneka Chingozi to please comment on the presentations, the topics that were handled by the various groups, please, and share your insights on the different topics and areas you feel need to be, brushed up on, that the presenters probably glossed over. So please, we invited Mrs. Onyeka Chingozi now to please take over.
Thank you so much. Please confirm you can hear me. I'm audible?
Yes, please, you're audible. I can hear you.
So much. So I begin with group 1. I believe they spoke on registrability of intellectual property. So beginning with that, you find that intellectual property ideally cannot exist outside of registration. However, we have some exception. Copyright is one of it. It exists automatically once it is fixed in a medium and once it is confirmed to be original. So fixation in the medium is what qualifies registration or existence, rather, of copyright. So what that means that if, for instance, I sing a song and I don't record the song, there's no copyright in that work. So usually you find people who say that I came up with an idea and somebody stole it and ran with it. That's what really happens. So somebody has an idea, conceives a business idea, like I have a song, I want to sing it, discusses with a neighbor, and then the neighbor goes and records the song. So ideally the person that records, I could be singing, and the brother next to me decides to do the singing, to do the recording. That means he's the what? Owner of the work. I may be like the voice that's been heard who sang the song, but he remains the owner of the work because he's the one that fixed the work in a medium. So usually you have conflicts, but I don't want to go into detail. Let's just keep it at registration. Another exception is in Europe, we have what we call unregistered industrial designs, community industrial designs, and their law allows for 3 years term before an industrial design that is not registered would expire. That means that industrial design that ideally should have been registered, if you are in Europe and then you come up with a design, for one reason or the other, you didn't register it and it goes into the market, it has protection within that 3 years period. So that would just be the exception you have there. Then for Nigerian law, you find that industrial property law, usually you have 5 years for industrial design. That's a term of 5 years, renewable for another term of 5 years, 2 times. That means total of 15 years. I felt that should have also been mentioned. You find out that for copyright under the Nigerian law, it will last for the lifetime of the author plus 70 years. However, the minimal allowed by the Berne Convention is 50 years. So which means national laws or countries can decide to extend, but they can't go below 50 years after the life of the author. For patent, I expected someone to also talk about utility models, which are now like smaller patents. So in Nigeria, we've accommodated that at the registry as well. So people who have patents that cannot exactly be registered on that patent, maybe because it's short, falls short of some of the requirements for patentability, which ideally are novelty, industrial applicability. So we want to accommodate such other utility models. So they are called smaller kinds of patents. Then also understand that an international scene, somebody talked about the registrability of IP laws at the regional level. Unfortunately, Nigeria is not a member of RIPO or WAPI. That means even if you want to register at the regional level, you still have to come directly to Nigeria to register in Nigeria. So even at the international scene, we find out that it's not all states, not all countries falls under the Madrid Protocol. We have about 180 of them. So any country that is still not represented there, it means you go to that country directly to take up registration. So it's important to have stated that intellectual property first is territorial. That's a major principle of intellectual property. Because you guys were the ones that started, I expected more resources, more information to guide other persons in their presentation. It's a pity group 2 didn't present. So I felt it was a bit sketchy. More would have come in, but because of time, we just moved. So moving to group C on enforcement. You talked about the digital enforcement and also analog. Okay, so you find out that for enforcement to happen, right from the point of registration, any kind of registration you want it to be, trademark, patents, or industrial design, there's usually that window period for opposition. So in Nigeria, particularly on trademarks, when you register a trademark, you have what we call when you file for a trademark and it's accepted, not yet registered. Registration doesn't happen until you've been issued with a certificate. So let me correct myself there. So once you file an application for registration and it's accepted, the next thing that happens is it's published in a journal. When it is published, it's a notice to the world that this name has been taken, or this slogan has been taken, or this logo has been taken. So what happens? You expect people out there to raise opposition if they find that the mark is similar to what is already existing in the market. Or even at the point of filing, the examiner may refuse such an application, citing that there is a similar name. So if we allow this name to go out there, it's going to cause confusion to those people who are going to be patronizing the goods. So they don't allow such registration. And if for any reason they allow it, during opposition, you have the right to bring opposition. You write to the registrar, notifying him of the mark and stating your reasons. And then you go through opposition trial. It's an administrative process. So that's where enforcement for me begins. Having done that, afterwards, if the mark for any reason is registered before you notice, then you talk about invalidation of the mark. That should also happen. So besides that, I moved to online. Yeah, you normally have cease and desist letter. You also have takedown notices, especially when it has to do with copyright or even trademark, whatever it is. You find out that the digital space has corrupted and disrupted a lot of intellectual property activities. Take, for instance, during the COVID, so many people went online singing, so many content creators are now online, so many businesses have been created, which is very beautiful. But with those advantages, we have huge disadvantages that also come with it. It's easier just with this phone. I might just go to any site. Just by doing that, I'm already infringing on the rights holders' rights, especially if I'm not doing it for my own personal consumption. When people share things on WhatsApp and you download, and then you start sharing, hello, it's okay to download it for your personal use, but once you start sending to other WhatsApp platforms, you may have already been infringing the rights of the rights creator. So people should be aware of that. And then when you talk about takedown notices, this has to do with ISPs, internet service providers, under the DMCA, that's domain name, Digital Millennium Copyright Act, under the US Copyright Act. You find out that the ISPs actually have a right to take down whatever you have put out there through their platforms. ISPs are platforms like YouTube, Facebook. So if you post something on your Facebook or your YouTube and it belongs to someone else, the person can notify YouTube, informing them of the content you have posted, and may also attach evidence of saying that it belongs to them. And then YouTube will also notify you, and they're expected to take down immediately, failure of which they will not be protected under safe harbor principle, which is provided for under the DMCA. So because of time, I moved to infringement. Unfortunately, the guys on infringement didn't present, but I went through their slides. So I'll be picking on, if you have the slide, the organizers may want to show us so that people can follow. So under infringement, you have on the slide 6, paragraph 3. You notice that there's that confusion between what happens in the domain name and what happens with copyright. There's a little bit of confusion from what I read in the slide. It looks like the group members didn't find out the difference. For copyright work, those are things like maybe software, books, songs, and what have you. But when we talk about domain name, those are names on the internet. They are like traffic, they are like pointers, they're like directors, just like your trademark. Your trademark is peculiar to you. It makes you known in the analog society. But in the digital space, what you have is domain name. It's like a traffic director. It directs people to your store, which is online, to purchase. So exactly what the trademark does, that's what the domain name does. However, what people don't know is before they take up domain name registration, mind you, you don't register under any of the IP offices. The people who register domain name are called domain name registrars. So they are provided for differently. But people should be aware that for you to register a domain name, you are meant to do a due diligence search. You search through the trademark registry, the IP registries, the company name registry, search on Google, go out there, do your market survey to make sure those names don't already exist before you register a domain name, because by registering a domain name, you may actually be infringing on the trademark. And then they cited a case that looked like if you have a domain name, you are protected, even though if somebody else has a trademark. So I wanted some clarity from the presenters, but I can't say much on that because they didn't present. So the case study, but what I pinned down was in a situation, even in that similar case study, that's slide 8, if you have it, please show it. Yeah, so this case study, looking at it, a hotel owner in Denmark who held a registered trademark. I'm seeing your face. However, from what I understand from what they put here, it looks like because the names, the owner of the trademark in Denmark is not online. Okay, he's online, but the one in Germany is not online. So it was okay for them to coexist. But it goes beyond that. Assuming the one that is in Denmark is a popular mark, okay? There are products who say they are popular, or there are brands who say that they are popular. So they become an exception to the rule, in that a popular brand cuts across all jurisdictions. Other international treaties, they are coded right as though they are registered in every country. So in a situation where they have a domain name, for instance, and they are not registered in Nigeria, but because they are LG, for instance, then that mark Hotel Maritime, if it were to be in Nigeria, would have been invalidated. So I hope we understand that. So moving forward to slide 10 and 9, about piracy and counterfeit. I could understand that maybe there's misuse of word. The word piracy usually features when it comes to copyright, but counterfeit usually have that for maybe trademarks. Because let me state this, under intellectual property is divided into 2 broad groups. You have copyrights on a separate part, and then you have industrial property. Under industrial properties, what you have are trademarks, patents, and industrial designs. So we use the word counterfeit to represent industrial properties. Piracy usually will feature under copyright. However, people should know that whatever is pirated is already a counterfeited good. It's not an original copy. So that element should be featured in that particular slide. And so talking about piracy, one of the disadvantages is this. The people who pirate other people's goods, what they do, they don't have staff they are paying, for instance, unlike the original producer of the work.
who has a staff, who has to go through a studio, he has to pay fees and all that. So people who pirate, they don't go through the sweat of the brow. Because in copyright, for instance, there's what we call sweat of the brow, which is covered under originality. For you to show that, yes, the copyright work is done, apart from fixation, there has to be originality. Originality concept simply means there was sweat of the brow. You did some work, okay? There has to be some element of the work is peculiar to you. You asserted some energy, and he that works should reap benefits of his work. So when you don't have that, somebody has pirated, he didn't run through those expenses, he went through the sweats, the timing and all that. He just goes and copies your work and puts it out there and is reaping benefits. Reducing the amounts that is supposed to be credited to your own account when people purchase your goods, if there were no pirated copies. So it also affects the economy of the country because they don't pay tax because government doesn't know they exist, more or less, not because they don't know there are pirates out there or people who pirate goods. No, not that. But because original business, they are already tracked to also commit their tax to government. But those who pirate, they do it maybe underneath, back of their houses and nobody even knows they're there. Then in the digital space, another way we can actually protect rights, because it's difficult for these right holders, especially copyright, to be able to track their jobs. Who is having a TikTok video out there, and then in the background there's my song playing without my permission? How do I reach out to the person in New York, Indonesia, or any other part of Africa? So we have people called CMOs, okay, copyright management of the organizations. So these guys can actually come together to assist to manage those copyright works. And then when they come in to manage those copyright works, it's easier because they can track on your behalf who is using your work and who is not. So they have to collect the monies and then distribute to all the right holders under their various platforms. Then ISP terms and conditions, people should be aware before they subscribe to maybe any ISP like those on. There was a time Facebook used to have that condition that whatever videos you upload, whatever intellectual property you exchange on their platforms belongs to them. So they can use it, they can share it. Imagine you have your new picture on Facebook. They can actually decide to license it to a phone house, and your video is showing in somebody's bedroom and you don't even know. And no money is going to be credited to your account. So people should know the terms and conditions they're signing before subscribing to some of these ISPs, but that has not been taken care of. Then awareness should be created in the open space, especially for the purposes of digital economy, so that people know what to do that amounts to infringement and what doesn't amount to infringement. On the other end, talking about arbitrability of intellectual property, pacta sunt servanda. Any right, for instance, if the two of us enter into an agreement, parties are bound by what they agree to do. So if we say this contract is going to be arbitrable, then so be it. Ideally, when it comes to patent, especially when you are testing for patentability, because people have a right, when the registrar says, for instance, your patent is not patentable or your application is not patentable, we have refused it. On such terms, you don't go saying you want to use arbitration. You go through the court process. And the court of first instance will be the Federal High Court for Nigeria. Depending on other jurisdictions, some have special courts for their intellectual property. So those are some of the things we should actually watch out for. And then there are some jurisdictions that will say that intellectual property are not arbitrable for so many reasons. Understand that they are personal rights, and then sometimes our civil procedural rules might not necessarily provide for enforceability of intellectual property because we don't have special courts, and then we don't have special judges. So like what obtains in places like China, where they have special courts, specially trained judges to attend to intellectual property cases, which is why arbitration is one of the benefits. Because in an arbitral proceeding, he expects that the experts should be IP trained experts who can actually deliberate on some of those matters and give them a good finding on it. And then the guy was asking, he doesn't know if arbitration can actually be, what was that word again? If it can be appealed. Ideally, you don't appeal because you chose to be bound by an arbitration rule, which is one of the benefits, unlike what you have in the normal courts. From Federal High Court, I can decide to appeal and go to the Court of Appeal, from there to the Court of Supreme Court, and then keep buying time for 20 years. Imagine a patent that expires within 20 years. What happens? Before the court finishes with us, then the rights are expired, then I have nothing. So one of the benefits of arbitration within a period of 1 month, 6 months, as the case may be, the matter may come to an end. You get your rights, you get your benefits. I pay your compensation depending on the wrongs I've committed. That'll be all for me for now, unless I have questions for you. Thank you.
Thank you, Ms. Onyeka Chingos. Oh, can you hear me? Okay, thank you, Ms. Onyeka Ngozi, for your contribution. Please, we'll be having Ms. Linekela Usiebu to please give us her own 2 cents on the presentation, please. Thank you.
Okay, good evening, everybody. I'd just like to first and foremost thank all the presenters for the work that you've put in. And yeah, I found that most of it was quite informative, especially when it comes to the jurisdictional aspect, in the sense that I'm not really well versed with the laws of Nigeria. So I did learn a lot in that regard. A few questions were posed. I'm going to try and attempt to provide guidance on some of those before I go into the comments that I have for the different groups. So I think the previous mentor addressed some of the issues that I also had comments on. So I'm just going to skip over those for the sake of time. But the issue of the finality of the award, I think what was one of the questions that was posed, whether there is really no alternative to accepting the outcome of it. I do know that in some jurisdictions, you can, in terms of the agreement, the pact that you've entered into to go for arbitration, you can also then, in terms of that agreement, agree to an appeal. If that is part of the agreement, then some jurisdictions do allow for an appeal. But most arbitral awards, if there is no appeal clause, then you can always follow the route of seeking a review. Now, a review, you're not necessarily appealing, but you are actually asking the court to determine whether or not there is the ruling or the outcome of the arbitration was legal, in the sense that the legality aspect. So some jurisdictions do allow for that. As for the question on whether IP rights can be enforced abroad, the previous mentor also mentioned the aspect of territoriality of intellectual property rights. So essentially, if it's not registered in that specific jurisdiction, you can't really enforce it. Your right that is now as a holder of especially registrable rights, trademarks, patents, and so forth. But there are certain international conventions that different countries have acceded to, and they're bound by those provisions. One of them is the Paris Convention, that actually, as well as the TRIPS, they actually make provision for the recognition of well-known marks, in the sense that the trademark doesn't need to be registered in the jurisdiction for you to enforce it, but by the mere fact that it has that well-known, it's a well-known mark, it then has that that sort of over the territory protection that you don't need to register it for it to be enforceable. And so that there's that, if I can call it an exception, yes. And then what the Federal High Court in Nigeria, I think that was addressed to a certain extent. So I'm going to go to the different groups. The first group that spoke on registration of intellectual property. Thank you very much for your presentation on that. When you're talking about registration, I think you can also touch briefly on the aspect of invalidation, or the striking of a mark from the register, for example. So you might want, at what point after the mark or the patent has been registered can one with a vested interest, let's say, come and ask for the deregistration of that specific IP. So you might want to look at your statutes and what they provide with regards to deregistration and invalidation of the different IPs. And I know that copyright in most jurisdictions, in all jurisdictions, it has automatic and independent right of existence, but some jurisdictions that do require the formality of registration, you might want to perhaps assess whether that actually makes enforcement easier, or is it just does it encumber the process? Does it make it cumbersome for the owner of that specific copyright? And so I specifically want to speak on trademarks. Or you might want to also look at what the Nigerian statutes provide with regards to unregistered trademarks. So I have a trademark and I've been trading with that mark for a number of years. People know that, oh, Linekela trades under that trademark. She provides this service or provides this good. And when they see it, they associate it with me, but it's not registered. So how can I enforce, okay, what is the position of the law with regards to those marks that have not been registered, but they sort of assigned and they're associated with a specific provider. In Namibia, we have common law remedy for unregistered trademarks to say that it's just because you've not registered your mark does not mean that the law does not protect it. We have common law protection. That means that you can essentially call upon unlawful competition rules to enforce, specifically passing off. That is where you're saying that, okay, that is my trademark. And if somebody else then wants to go and register something similar because it's not in the register, right? You'll say, you can argue that this person is basically passing off my mark as though it were theirs, which has consumer protection implications. You're trying to deceive consumers and so forth. So you might also want to touch on that aspect. Yes, a lot of the IPs require registration for it to be enforceable and so forth. But specifically with trademarks, there is then the aspect of protection granted in some jurisdictions for trademarks that are not yet, they're not registered, but they have attained a reputation, if I can put it that way. So you might consider looking at that aspect as well. And then I think the previous speaker, and I also mentioned briefly the aspect of well-known marks. So look at the Paris Convention for that, which is also then incorporated in the TRIPS agreement. So when you do talk about your international agreements, then you'll find that each of these IP regimes have their own, there's an international source, and a lot of some of the laws are then crafted around ensuring that those minimum standards that countries have acceded to in the specific agreement are complied with within their jurisdictions. And that's just, it's a whole international law rules and principles that govern that aspect. But I would like to thank you for the effort that you put in that presentation. I did learn a lot. With regards to group 3, I think I just have one comment, and that is to ask you to think about the issue of concurrent remedies, where you have, let's say, copyright infringement, which is criminalized, and then you, as the owner of the copyright, also want to enforce your right in terms of civil proceedings. So can the two processes run parallel to one another within your jurisdiction? So you might want to speak on that. Does it mean that if the person is found not guilty or guilty of criminal copyright infringement, that you don't have a civil remedy anymore, or does the outcome of the criminal proceedings with regards to infringement also then influence the outcome of the civil proceedings? So you might then want to talk about that. And then with regards to remedies, you mentioned, Anton Pillar, the order that one can seek. But then you find that when you look at the different IP regimes, copyrights, trademarks, there are various remedies that one can ask the court to grant you. Yes, you've issued a cease and desist and it doesn't work. So then the person feels they're entitled to that specific IP, you feel you're entitled to it, and so the both of you then decide to go to court. So what can you ask the court to grant you? You have interdicts or an injunction, you have reasonable royalties, so all that. So with regards to the specific IP regimes, you might also then want to talk about the remedies or the what you can ask the court to give you. I don't want to, because I don't know the words that you use in Nigeria for some of these things, but I'm sure you understand what I'm trying to say, and it could be that it's the same expressions. So, but touching on some of those issues could assist your presentation as well, in addition to the other guidance that you got from the other mentors. So, but thank you very much for your presentation as well. I do acknowledge that you put in a lot of work. So then I would like to go to group 4 finally. I'm not gonna speak to group 2 because I think the issues that I did have were addressed. I think the first thing that I would like to mention is I already mentioned the aspect of the finality peer review. So with regards to international disputes, we're talking about, there's now the infringement is crossing borders or whatever you want to call it. And then the matter goes for arbitration. So how do you then enforce that arbitral award? Yes, you've agreed in terms of your agreement, you've entered into an agreement to go for arbitration, and then you're granted an award and the person is like, I'm not going to follow that award, or they're non-compliant with the outcome of the award. So how can you ensure that there is then this enforcement of an international, a foreign arbitral award, if I can put it that way? So you can consider the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. I went on the site, and Nigeria has acceded, is a party to the convention. I think you joined around 70s. So that is one convention that a lot of the jurisdictions also craft their national laws on arbitration around, in addition to the ancestral model law on arbitration. So that one is what they developed their law around, and then the New York Convention is what then allows them to enforce and recognize foreign awards. It's then your private law, private international law issues where you are now trying to enforce foreign awards. So I think if you can consider adding that to your presentation, that would also, I think, beef it up a bit and also provide a wider context in that regard. But thank you for your presentation. Thank you very much for that. You can also consider mediation. I mean, there are other ADR mechanisms available. I know arbitration, people like it because it's like, it's close to a court order, but you're sort of not caught up in the court process and the delays, and like it was mentioned, 20 years you're waiting. So it's faster and more efficient, but you can also then consider other ADRs and whether they can actually be useful in the process of dealing with IP disputes. Thank you very much. That is all from my side.
Thank you so much, Ms. Lenikela Usebio. And thank you so much, Ms. Onyekachi Ngozi, for your contribution so far. I've actually learned a lot about the whole arbitration process, and funny enough, the new conventions, or the sort of old but new, because I'm just learning about them now, that Nigeria has assented to in the international community, like the New York Convention that Ms. Lenikela mentioned. We want to show your gratitude for making our time to join us today. It's really a privilege to have you join us for this time of 2 hours. You listen to us talk. You painstakingly went through our presentations, and you had contributions to make. You had amendments, or you had comments on each point where you felt we didn't get it right. So we appreciate your time and your effort. So please, right now we'll be having the picture time. So please, I'll encourage each of the mentees to turn on their cameras so that we could get pictures, so that you can have evidence to post on your LinkedIn at the conclusion of the program, or even later during the week, telling your LinkedIn family that you are part of the program, and tagging our mentors along, because it shows that their time wasn't wasted. So please turn on your cameras and take screenshots. I would appreciate that, and I believe the mentors would also appreciate that, because that shows a level of acknowledgement on their part, to show that you appreciate the time that they took out to come and lecture us, or give us insight into the world of intellectual property law. Okay, so I believe everybody's done with that now. So going forward, we'll be entertaining questions. So does anyone have questions, maybe from the work that was done, any area that was unclear, but you just, glazed over it, or something that was mentioned in the course of the session by the mentors where they're making their corrections? Is there anything you feel that, you want the mentors to speak on or to address? Please raise your hand to indicate so that I can call on you. And please turn on your video when you're talking, so that we can, catch a glimpse of your pretty faces, please. So any questions that we can entertain, if you want to have a, more of a one-on-one with the mentor, now's your opportunity to. Any questions, please? Okay, we will be taking Tijani Salaudin. I hope I got that correct. So we'll be taking Tijani, please. Tijani, please go on.
All right. Good evening, everyone. And thank you.
Hello,
Tijani, I think you are muted. You can unmute yourself, please.
Oh, sorry. I was just trying to say that I appreciate our mentors for today's session. And my question is, so I had, it seems group 3 or group 2, they spoke about infringement of IP, I guess. And then the speaker said something about you need to to inform the infringer that, okay, you have infringed on my rights before you can before you have the right to access the court. My question is, okay, what if the infringement he did, or let's say it's the infringement he did, the infringement goes a long way. It goes a long way more than informing him rather, if what he did to you is to affect your reputation, and I don't even think him bringing out that thing can even can suffice for that reputation that he has breached. I don't know if you get what I'm trying to say. So would you still be able to access the court even without, or let's say you've told him, yes, that you've infringed my right, but can you still access the court without him further infringing that right? Sorry, can anyone hear me?
Yes, we can hear you. So Ms. Onyekachi Ngozi can go first, then Ms. Lineka can also contribute to answering that question.
All right, thank you. When I was talking about infringement in the digital space, I think that was when I made reference to the takedown notice and then the cease and desist letter. Even in the analog space, ideally, somebody should infringe on your trademark, for instance. You are still expected to let the person know. It's possible the person doesn't even know he's infringing on your rights. Using cease and desist letter, you can tell somebody that, okay, you send a letter either through your lawyer or personally, bring the information to the person's notice. I've registered this mark, or I'll be using this based on common law, jurisdiction that allows for passing off of rights, protection. So depending on the jurisdiction, what is obtainable, you find out that in some places like Nigeria, for you to enjoy your trademark, for instance, you must be registered. However, we create room for common law because we're a common law state, whereby somebody had been using, so we call it first to use marks. If somebody had been using a mark for so long and it has been known and the mark has become distinguished and people know the mark and associate it to that particular business, then the person has derived the rights under common law and can actually come after you as passing off. So the person is not claiming trademark infringement, however, passing off of rights. So when you inform somebody, you are not prevented from going to court. If you have informed me and I continue to do what I do, you would have put it in your letter. Let it have an element of threat. If after 2 weeks or 1 month or 2 months, you are still doing what you're doing, I'm going to take the matter to court. So you are still allowed to go to court. Because if you don't inform somebody they are infringing on your rights, they wouldn't know, right? You agree that they wouldn't know. And then sometimes the court wants to know that you actually tried out some ADR mechanism because you have informed. So he's expected to come forward and say, okay, let us negotiate. I didn't know this mark belongs to you. But now that I know, can I partner with you? Can I be one of your distributors? Not every time you see elements of infringement that somebody should actually run to the court. It can actually be an opportunity for business relationship in the sense that if I infringe on somebody's mark and I didn't know, or perhaps I knew and I pretended not to know, and then you reach out to me, it could be an opportunity for me to say, okay, let me take a license from you. So I'll be paying royalties. So I continue to do what I do. Do you understand? So it's not all the time it should end in a chaotic manner. Thank you.
Thank you, Ms. Onikachi. Please, does Ms. Linkela have anything to add to what she's already said?
No, I absolutely agree with everything that has been stated, but I think the rationale behind the cease and desist letter is just, these are private rights. So, and we all acknowledge that there is nothing new under the sun. So you can come up with the same idea that I have, and I don't know that you have the same idea. So, and if you are first in right, first, if you go and register first, then that means that idea is yours. So the rationale, my understanding of it is just to inform the person, because like it was mentioned, they might not know that there is a trademark registered, or there's there's somebody else who holds the right to that specific concept. So or a similar concept that may cause confusion in the market. So then the idea is just to say, okay, you are now treading too close to my right. Please take note that I have the exclusive use of this trademark, and your conduct is threatening that specific exclusive right that I have, and I'm just informing you. And if you do not stop, then I will go to court. So it like it was mentioned, you can then, the person can say, oh, I didn't know, or they can say, actually, it's mine, and that's now when the dispute starts. But most of these issues don't go as far as court, because the person may desist unless they really feel they have a legitimate claim to that specific intellectual property.
Thank you so much, Ms. Linkela. Thank you for your contributions. Please, does anybody have any further questions to ask? Anyone with questions, please? Okay, it seems there's no other question. right now. So I would like to personally, and on behalf of the internship and mentorship program organizers, to thank Ms. Linkela and Mrs. Onekachi Ngozi for making out time to mentor us, to open our eyes to areas that we overlooked in the course of our presentation, in the course of our research, and helping us to understand better or to be more abreast with the intricacies of the intellectual law practice and the space in general. So thank you so much for making our time. And then for the mentees, thank you for researching, for putting the work, for coming together as a group to come up with the slides. And I believe the articles were also done individually by like each mentee that was assigned to that. And for the group leaders that helped to organize everything, I appreciate your efforts, and I pray the Lord blesses each and every one of us and gives us strength. So thank you so much, everybody, for making our time. On this note, we'll be bringing the meeting to a close. We'll be inviting Mr. Hussein for final parting words, please.
Okay, thank you very much, everyone. Thank you very much, Ms. Onekachi and Ms. Linkela. Special thank you from Jiipcc. And thanks to the mentees that stayed with us from the beginning to the end. I believe we all learned something new today. The mentors learned and the mentees also learned. So that was one of the objectives of the program, is continuous learning. And some of these things we learn here, we don't get to learn it from our lecturers or in classrooms. So we thank everybody once again. We'll see you next Friday, the same time, and have an amazing weekend. Thank you. Bye-bye.
Thank you. Bye.
Bye.
Bye. Good night.